Welcome to The Explainer. Today we've got a story that has it all. You've got a devastating fire, a huge fortune at stake, and, wait for it, a Supreme Court ruling that all came down to a Wikipedia article. Seriously. We're going to dive into how a simple argument about rust ended up in the highest court in the land.
So on the surface, this whole thing starts out pretty normal, right? It's a story you've probably heard before. A company has a fire, their stuff gets wrecked, and they file an insurance claim. Happens every day. But this particular case, it took a turn, a really wild turn that launched it all the way to India's Supreme Court. Okay, so what was the big deal? What made this case so weird? Well, get this. A lower court, faced with a really tough technical question, decided to look for answers on Wikipedia. Yep, you heard that right. And that one move became the absolute linchpin of this massive legal fight. So we've got to figure out, how on earth did that happen? And maybe more importantly, what did the Supreme Court think about it? All right, to really get a grip on the final verdict, we need to go back to the beginning. Let's break down what this whole fiery dispute was about. Okay, so let's meet our key player, Super Label Manufacturing Company. Now, these guys aren't just making simple stickers. They're in the high-tech label game, using some seriously sophisticated and very expensive imported machines. And, like any smart business, they insured the heck out of this stuff. We're talking a policy for over 3.3 crore rupees. That's a huge safety net for the heart of their operation.
So, picture this. Morning of February 28, 2004. Disaster strikes. A fire rips through the factory. The fire brigade rushes in, and for more than 2 hours, they're blasting the place with water jets to kill the flames. Eventually the fire's out, but the damage is obviously done. Super Label does what you'd expect and files their claim. But I want you to lock in on that one detail, the water jets. Because believe it or not, that becomes the absolute crux of this entire fight.
And right here, this is where things go from being a simple insurance claim to a really complex, rust-stained mystery. See, nobody was arguing that the fire didn't happen. The huge fight was over one thing. What was the damage actually worth?
So after the smoke cleared, Super Label looked at their machines and basically said, they're a total loss. They filed the claim for just over 3 crore rupees, figuring the core of their business was just gone.
Now, the insurance company sends out their own guy, a surveyor, to check things out. That's standard stuff. And his initial report? It actually came in pretty close. He assessed the loss at a whopping 2.26 crore rupees. So, at this point you're thinking, okay, they're in the same ballpark, they'll figure this out.
But then, boom, the twist. After some more internal chatter, the insurance company comes back with their final offer. And it's not 2 crore, it's not even 1 crore, it's just over 16 lakh rupees. Can you believe that? From a claim of 3 crore down to this tiny fraction?
So what on earth happened here? How do you justify that? You go from a 3 crore claim all the way down to just 16 lakh. That is a massive 94% reduction. The rest of our story today is all about solving that exact mystery.
Okay, so to figure this out, both sides did what you'd expect. They brought in the big guns. They're experts. And the whole thing turned into this intense technical showdown, a real battle of the experts. And it all came down to one single thing, rust.
So let's look at the two corners. In Super Label's corner, you've got the machine's own manufacturer saying, yep, it's a total loss. On top of that, a report from the super prestigious Indian Institute of Technology, that's IIT, said that, yeah, with fire and water, this kind of intense rust could entirely feasibly happen in just a few hours. But in the insurer's corner, another expert report claimed the total opposite. They said there's no way that much rust could form so fast, hinting that it must have been an old problem.
So, since they couldn't agree, the case went to the National Consumer Disputes Redressal Commission, or the NCDRC. The commission looked at this battle of experts and they sided with the insurance company. But it's how they reached that decision that makes this story so nuts.
And here it is. This is the moment. To decide between these two heavyweight technical reports, what did the NCDRC turn to? Wikipedia. I'm not kidding. They literally cited the opinion in the website Wikipedia about corrosion to decide that the rust had to be old, that it formed over years, not hours. They just threw out Super Label's entire argument based on a Wikipedia article.
Well, Super Label wasn't having it. They refused to give up and appealed all the way to the top, the Supreme Court. And when the justices got the case, they didn't get stuck in the weeds arguing about the science of rust. Nope. They looked at the whole problem with a completely fresh set of eyes.
So up until this point, everybody, including the NCDRC and its Wikipedia entry, was just obsessed with this one question, right? Could this much rust really form in just a few hours? The whole case seemed to hang on that one scientific detail.
But the Supreme Court did something, well, brilliant. They basically said, everyone, you're asking the wrong question. This was never about the chemistry of rust. This was a legal question, and it all boiled down to a core principle called proximate cause.
So, what in the world is proximate cause? Think of it like a line of dominoes. In insurance law, you're not looking at the last domino that fell. You're looking for the first domino that someone pushed, the one that started the whole chain reaction. It's the single dominant cause that kicks off an unbroken chain of events. The big question is, were all the events linked together, one after another, with no new force coming in to interrupt them?
So the Supreme Court just laid out that chain of dominoes, step by step. Let's walk through it. Domino 1, the fire starts. That's the covered event, the peril. Domino 2, the fire brigade shows up and sprays water. That's not some random event, it's a direct and necessary response to the fire. Domino 3, the water hits the hot metal and causes massive, rapid rust. And Domino 4, that rust completely ruins the delicate precision machines. See? The court saw it as one single, continuous chain. The fire was the first domino. It was the proximate cause of everything that happened after.
So by applying this simple, powerful logic, the court was able to cut right through all the back and forth and deliver its final verdict. And that verdict has some really big takeaways for all of us.
The court also made another really important point. They doubled down on a key principle in insurance law. They said, look, if a contract is ambiguous, if there's a gray area, like you see here with two dueling expert reports, you have to resolve that ambiguity in favor of the person who bought the policy, not the company who wrote it. That is a huge piece of protection for all of us.
And with that, the Supreme Court completely overturned the lower court's decision. They ordered the insurance company to pay up, using that original surveyor's number, over 2 crore rupees plus interest for all the years they waited. After that long, hard fight, it was a massive win for Superlabel, completely wiping out that unbelievable 94% reduction.
You know, this whole case leaves us with a really powerful final thought, doesn't it? It's all about perspective. The lower court got so bogged down, focusing on just one tiny, broken link in the chain, the rust, and it almost led to a huge injustice. But the Supreme Court won the day by stepping back and seeing the entire chain of events. It's just a great reminder that sometimes finding the right answer isn't about knowing more, it's about asking the right question in the first place. Thanks for joining me on The Explainer.